further to show prima facie the violation alleged and its effect before a question could be referred to the Constitutional Court. Most references tend to provide an escape from justice by indefinitely staying and delaying the proceedings, thus prolonging the system. End of quote. In the case of Haji Yusuf Bagale and Ssewanyana versus Damaniko Properties and Attorney General, this Constitutional Reference number 20 of 2021, the Honorable Justices of the Constitutional Court observed that the Chief Magistrate in that case had made a constitutional reference, even though she found that no question had been raised for constitutional interpretation. In that case, the Chief Magistrate ruled as follows, and I quote, "Thus, in my opinion, on ground of jurisdiction, this application has not yet been heard. There is no question to be determined by this Constitutional Court. But since Counsel quoted articles of the Constitution in his question, and since this court has no interest in the matter, as is trying to allege, the same is hereby forwarded to the Constitutional Court for interpretation of his question." In light of the above, the justices of the Constitutional Court observed that, I quote, "It appears that the Chief Magistrate accepted to make a reference at the insistence of counsel for the applicants. The Chief Magistrate was quite right when she stated that there was no question to be determined by this court in her ruling set out above. She ought to have stuck her guns and refused to make a reference. This is what the judicial oath requires: administer justice without fear or favor." And that's the end of the quote. The court further stated, I still quote, "This court has long departed from its earlier decision in Tyson, Kk and another versus Attorney General and another Constitutional Application number 13 of 2007, where it had held that clearly the court requested by a party to make a reference to the Constitutional Court has no option but to forward the questions framed by the same party. In the instant case, the land Chief Magistrate did not have to consider the merits of the applicant's application, but to make a reference to the court for determination and only wait for the outcome. This holding is no longer good law. The current position was recently summarized by this court in the Constitutional Petition number 46 of 2021 and Constitutional Reference number 54 of 2021, that is Honorable Sam Kutesa and Attorney General, where it was observed that both the Supreme Court of Uganda and the Constitutional Court have in a way dealt with this issue. In the Constitutional Appeal number 2 of 1998, Ismail Sergo versus Kampala City Council and Attorney General, the CJ, as he then was, stated as follows: "In my view, the Constitutional Court to have jurisdiction, the petition must show on the face of it that the interpretation of a provision of the Constitution, constitutional provision is required. It is not enough allege merely that the constitutional provision has been violated." In light of the above position of the law, as evoked by the Constitutional Court and the Supreme Court, it is clear that it is no longer mandatory for the court before which a request for constitutional reference has been made to simply refer without considering whether the question is meritorious. In the case before me, the question I have to answer is whether the questions raised require a constitutional interpretation. I will handle the first and second questions concurrently because, in my opinion, they raise the same issue. I will produce the question as follows. 1. Whether the reduction / protection of witnesses in the manner within the court's ruling in miscellaneous clause number 14 of 2022 contravenes and is inconsistent with Articles 28 and 44 of the Constitution of the Republic of Uganda. And 2, whether Rule 22 of the Judicature High Court International Crime Division Rule 2016 is inconsistent with and contravenes Article 28 and 42 and 44 of the Constitution of the Republic of Uganda as amended. I need to mention that miscellaneous clause number 14 of 2022 was premised on Rule 22 of ICD rules for restricted disclosures, and application was allowed with the following orders. A, that there shall be redacted disclosure of 15 witnesses, that there shall shall be summary disclosure of the evidence of two witnesses, that the redacted and summary disclosure shall be done by 7th October 2022, that full disclosure of the identities of the witnesses and evidence shall be done not later than 15 days before commencement of the trial should this court confirm the charges. Rule 20 of the ICD rule gives the pretrial judge powers to make necessary decisions regarding disclosure between the prosecution and the defense and the accused person. Rule 21, sub-rule 1 thereof provides as follows. Subject to Rule 22, the prosecution shall provide to the pretrial judge and the accused person for the purpose of the pretrial hearing no later than 15 days before the date of the pretrial hearing any relevant evidence or material which the prosecution intends to present at the hearing. Rule 22 provides for restrictions on disclosure, and sub-rule 2 provides thus: where evidence or material on which evidence will be based is in the possession or control of the prosecution, which must be disclosed in accordance with these rules, but disclosure of which may prejudice further investigation, the prosecution may, not later than 15 days from the date of the trial, apply to the pretrial judge for a ruling as to whether the material information must be disclosed to the defense, and the matter shall be had ex parte by the pretrial judge. Rule 22 and sub-rule 2 thereof enjoins the pretrial judge, trial judge, or trial panel to take steps either on his own motion or at the request of the prosecution or defense, ensure the confidentiality of the information disclosed, protect the safety of the witnesses, victims, and members of their families. This may be done through authorizing non-disclosure of the identities of the witnesses prior to the commencement of the trial, disclosure in a summary form without a disclosure, delay disclosure, among others. The International Criminal Court's rules of procedure and evidence, which regulate procedure in the International Criminal Court, has similar provisions for restrictions on disclosure of the witnesses is not compromised. Counsel for the accused persons argued that the ICD rules, which allow restricted disclosure, are inconsistent with and contravene Article 28, 1, 3, A, C, and G of the Constitution because they deny the accused person the right to know the evidence the prosecution intends to produce against them. It was then that counsel for the accused asked this court to refer the question for interpretation to the Constitutional Court. In order to better appreciate the issue at hand, it is important to reproduce here the provisions of the Constitution. That is Article 28. Civil rights and obligations when a criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by the law. 3. Every person who is charged with a criminal offense shall A. be presumed to be innocent until proved guilty or until that person has pleaded guilty. C. Be given adequate time and facilities for the preparation of his or her defense. And G. Be afforded facilities to examine witnesses and obtain the attendance of other witnesses before the court. The right to fair hearing under the above provisions of the Constitution and pre-trial disclosure was exhaustively discussed and interpreted by the Constitution in the case of Sun, which is already referred to above, where the justices of the Constitutional Court, while relying on the Kenyan court decision of Juma and others of Kenya, and then the South African case of Shabarara and 5 others versus Attorney General, they observed inter alia, and I quote, "We have stated here above that Article 28(1) and 3 require an accused person charged with any criminal offense to be presumed innocent and to be afforded all material statements and exhibits, enable him or her prepare his or her defense without any impediment. This is pre-trial disclosure. This disclosure is not limited to reasonable information only. Counsel for both parties have agreed that the right to disclosure is not absolute. We respectfully accept that view. Such a disclosure is subject to some limitations to be established by evidence by the state on grounds of state secrets, protection of witnesses from intimidation, protection of the identity of informers from disclosure, or that due to the simplicity of the case, disclosure is not justified for purposes of a fair trial. This means that the accused person is prima facie entitled to disclosure, but the prosecution may, by evidence, justify denial on any of the above grounds. It is the trial court that has the discretion whether the denial has been established or not, and that's the end of court. The Constitutional Court further observed that, I quote, "We are unable to give any hard and fast rule as to the time of disclosure because the circumstances of each case differ. Essentially, disclosure should be made before the trial commences, depending on the justice of each case and on which documents to be disclosed. This is within the discretion of the trial court." In summary, Article 28(1)(3) A, C, D, and G of the Constitution of Uganda, in their plain, natural, and practical meaning, prima facie entitle an accused person in a magistrate's court to disclosure of A, copies of statements made to police by the would-be witnesses of the prosecution, B, copies of documentary exhibits which the prosecution is to produce at the trial, and C, the disclosure is subject to limitations to be established through evidence by the prosecution. In light of the above, it is clear that the Constitutional Court has already given guidance on the interpretation of Article 28 of the Constitution, the right to a fair hearing and fair disclosure. For us, the justices of the court stated that the right to a fair hearing entails disclosing material evidence to the accused person. They also stated that disclosure is not absolute, but is subject to some limitations established by the evidence, by the state on grounds of state secrets, protection of witnesses from intimidation, protection of the identity of informers from disclosure, or that due to the simplicity of the case, disclosure is not justified for purposes of fair trial. They also did not give any hard and fast rule on when disclosure should be done. They left it to the discretion of the trial court to determine whether there is justification for limiting or restricting disclosure to the accused persons, depending on the evidence available to the trial judge justifying the limitations. Counsel for the accused argued that the case of Soon was decided in 2008, and in June, ICD rules were issued in 2016, and their constitutionality has not been tested by the Constitutional Court. Upon the rules of the rules, I find that they are in conformity with the Constitutional Court decision in the Soon case. This is because they provide for disclosure as a general rule in Rule 21, and make exceptions for restricted disclosures in Rule 22 thereof when there is need, and gives the trial judge the powers to make decisions on pretrial disclosure. This is exactly what the justices of the Constitutional Court ruled in the case of Soon. They clearly stated that they could not give a hard and fast rule on when and how disclosure should be done, but left it to the discretion of the trial court. Counsel for the accused persons further contended that the Soon case did not offer guidance on how to strike a balance between the rights of the accused person and the need to protect our witnesses, and this application for the reference is intended to achieve that. As already observed, the Constitutional Court ruled that they could not give a hard and fast rule on how to strike that balance, but left it to the discretion of the trial court. And it is also my view that the ICD rules also provide for that balance in Rules 20, 21, and 22. While making orders in miscellaneous Court number 14 of 2022, I was very mindful of the need to ensure the balance between the rights of the accused person and the need to protect the witnesses from any risk that may arise as a result of full disclosures of their identities at this stage of the trial. I ordered for disclosure of some statements in summary form and redacted disclosure of others. I also ordered that full disclosure of the identities of the witnesses shall be made not later than 15 days prior to the commencement of the trial. Should this court confirm the charges? I strongly and I'm very satisfied that this brings about the required balance between the need to observe the rights of the accused persons to a fair hearing as enshrined in Article 28 of the Constitution and Article 44 thereof, and the protection of witnesses. Counsel for the accused persons also argued that the ICD rules are relatively new and their constitutionality has not been tested. That's a need to have a constitutional reference to attain that. I respectfully disagree with this argument because since 2016, when they were issued, they have been applied with no complaint, and specifically with regard to protection of witnesses. There are a number of cases that I have mentioned which have applied those rules. It also goes without saying that this division of the High Court aims at operationalizing the international standards applicable in the International Criminal Court of the Rome Statute, to which Uganda is a party, and therefore guiding the practice of the court. The International Criminal Court was established to try crimes of genocide, cases against crimes against humanity, war crimes, and crimes of aggression. And by the High Court's International Crime Division practice directions of 2011, the crime of terrorism was added on the list, on the above list, for the offenses to be tried by this division of the High Court. In keeping with the international principle of pacta sunt servanda, which means that arguments must be kept, Uganda having signed and ratified and domesticated the Rome Statute by the enactment of the ICC Act 2010 is bound to perform its obligations under that instrument. I therefore find that the provisions of the Judicature High Court International Crime Division Rules 2016 are neither illegal nor unconstitutional. These rules are issued under Section 41(1) of the Judicature Act, Chapter 13, and Section 40 of the Judicature Act provides for the establishment of the Rules Committee with a mandate to make rules for regulating the practice and procedure of the Supreme Court, the Court of Appeal, and the High Court of Uganda, and for all other courts in Uganda subordinate to the High Court as provided for under Section 51(1) thereof. The rules are in line with the interpretation of the Constitutional Court on the right to a fair hearing as enshrined in Article 28 of the Constitution and disclosure in the case of Sun, as discussed above. In light of the above, therefore, I find that questions 1 and 2, as raised by counsel for the accused person, do not call for constitutional interpretation because the Constitutional Court already pronounced itself on the same in the case of Sun, and the ICD rules are clearly in line with that court decision. I therefore decline to refer the 2 questions to the Constitutional Court for interpretation. This takes me to the third and last proposed question, which reads as follows. Whether the act of proceeding on similar charges based on similar facts to try the accused persons, both at the International Crime Division, Kampala, and High Court, Masaka, is inconsistent with and contravenes Article 28 and 44 of the Constitution of the Republic of Uganda and the Union. From the outset, I wish to observe that I have reservations on the way this question was framed. It creates an impression that this court ordered for parallel criminal proceedings, one in Masaka and one before the ICD, on similar charges based on similar facts. However, this is not true because this court observed that the 2 cases do not have similar charges and similar facts, though the offenses are of a similar character. This court also observed that whereas the count of murder in the realm of file could have been added on the indictment on the case before this court because they are of a similar character, and whereas Honorable Alan Ssewanyana Aloysius and Honorable Muhammad Ssegirinya could be added on the indictment before this court, the third accused on the realm of file, named Senyonga Wilson Elias Nyonga Tony, his F3, could not be safely added on the indictment because this case, before this court, because he was a complete stranger. He was a complete stranger to the case, and adding him would be a misjoinder of persons. For the avoidance of doubt, the finding of this court on that aspect read as follows, and I will quote it. Applying the above cited law, the facts before us, the only provision that would be applicable is Section 24(3) of the TIN, if the applicants were the only accused persons appearing on the charge sheet of Rengo, CRB 203 of 2021, they would certainly be added to the charge sheet of Massacre, CRB 605 of 2021. This is because the applicants would be persons accused of more offenses than one, of the same kind. However, there is another accused person, namely Senyonga Wilson alias Nyonga Tony Ekiriwo, on the charge sheet of Rainbow CRB 203 of 2021, which makes the joinder of persons impracticable. Had it been the case that Ekiriwo also appears as one of the accused persons in Massacre CRB 605 of 2021, then the joinder of persons would be possible. However, Ekiriwo is a total stranger to the case that is currently before this court, and this court has not had the opportunity to hear from him. Moreover, Rainbow CRB 2021 has never been brought before this court. As such, bringing Ekiriwo to the case before us with the accused persons in an away law would be a misjoinder of persons. In light of the above, therefore, it is clear that the persons in the charge sheet of Rainbow CRB 203 of 2021 cannot be safely joined on the charge sheet of Massacre CRB 605 of 2021, thereby answering the second question in the negative. Having made that finding, I also find that failure by this court to order for a joinder of counts and persons in the two case files that are the subject of this application does not in any way violate the applicant's rights to a fair hearing and is not prejudicial to them in any way. The two matters can be safely handled separately. That's the end of the quote. The above notwithstanding, I also find that Article 137, 5B of the Constitution that counsel for the accused person seeks to rely on states that the question for interpretation should arise in the proceedings in a court of law. This, in my understanding, means that the question should arise when the proceedings are subsisting. The third question arises out of miscellaneous application number 19 of 2022, which was concluded and a ruling delivered on 28 September 2022. This therefore means that concerning that application and any issues related to it, this court is found prosecution. And as a presiding judge in that application, I cannot revisit it to frame a question out of it for reference to the Constitutional Court for interpretation. In light of the above, therefore, I also decline to refer the third question to the Constitutional Court for the reasons stated above. Resultantly, this application fails. The pre-trial of criminal session case number 004/2022 shall proceed on the date to be agreed to by the parties. And that is the order of the court. Now we still have to fix this case. Okay, will you please agree on when we come back to proceed with the trial hearing?
We propose 7.
What is happening in October?
Sorry?
What has happened in October?
Your Lordship, our October is jammed up.
I'm available on the 25th of October.
Our diaries, my lord. We actually were thinking of a month, but we thought it would be far.
I actually thought you people wanted us to conclude this matter.
Yes, but properly we do not.
When we are present, we will
Definitely, you have to be present.
We don't want to miscarry our
Okay.
affairs. So 7.
7 is a Monday.
It's a Monday. Some Mondays.
Okay, by consent of both of you, the matter is adjourned to the 7th of November 2022 at 9:30 a.m. for further hearing. The accused persons are further remanded still being.
So, we'll paka na musango omwezi ogw'okunogumu kusaaza tuna ekitundu.
And you can access your signed copy in the next 30 minutes.
Era ensala y'omusango guno ejja kuvaawo ntekikangaza kutabo kitunawo kopi.
Signed copy.
Eriko omukono gw'omulamuzi.
Thank you so much.
Yabanga Salongo John.
Mukazi musajja abaana b'abantu bavundira mu makomere watali musango. Tukoye ng'abantu batalina genda bitala abaana
Yeah, anyway. Right or not, who said Salongo John to Jacksonville? But anyway, today was a decision of this Honorable Court to determine on whether the questions we wanted both before the Constitutional Court for interpretation will be accepted by this Honorable Court. That application has been dismissed by this Honorable Court. It disagrees. According to this court, the rules of this court, first of all, because no one has ever complained about them, then they have no problem. But we complained. Secondly, that the witnesses can take priority to the Constitution. I think it's also absurd. We have received this decision. We shall respect it to the extent that this court has the discretion. We are going to look into whether it exercised that discretion in denying us the opportunity to go before the Constitutional Court, whether it exercised it judiciously. That we have to discuss with our clients and our colleagues, lawyers, and we shall come back to you on how to move forward. Twazze mu kooti eno nga tugamba nti amateeka agaleetebwa ICD division gamenya akawaayiro ka constitution akawa omwawaabirwa obuyinza ne beetu okuba nti naafuna obujulizi okusobola okwetegekera okwewozaako omusango gwe. N'ekyokubiri nga tugamba okuba nti nno emisango ebiri egifaanagana nga kooti nayo bwekkirizigana naffe negifaanagana gibeera mu kooti ebbiri ez'enjawulo, nakyo kimenya constitution article 28 because it's double jeopardy. You are trying me in two different courts on similar charges, as has been confirmed even by this ruling. So we believe bali mu kuteeka abawawaabirwa mu kooti eno n'ey'e Masaka ku misango egifaanagana. Ene kooti nakyo ekikkiriza ne mu nsala eno nti emisango egiri wano n'emisango egiri e Masaka gifaanagana. Naye nti olw'okuba abantu abali ku musango gw'e Masaka bonna si be bali wano, then kyekitegeeza nti nno emisango tekisobola kuleetebwa wano. Tulowooza ebyo byonna byonna bimenya constitution. Ki kye tulabye olwaleero nti kooti eri mu kusukkulumya rules as against the constitution. Tulowooza amateeka okujjako nga tugazzeemu olwaleero tosobola kusukkulumya rules. Kasita omuntu akulaga nti nno gano amateeka g'otambulizaako kooti eno gamenya constitution, gwe bw'oba toyagadde kiraba ne tukusaba nti tugende mu constitutional court erina obuyinza okuinterpretinga oba amateeka ago gamenya constitution n'otugaana okugendayo nga tolina buyinza buinterpretinga constitution gye tukugamba, then tuba tulowooza osazeewo mu bukyamu. Tukikkiriza nti kooti erina obuyinza obutunula mu nsonga zino n'okusalawo ng'egi esalawo, ne tuwakanya engeri gye kooti gye zikuttemu ensonga za Honorable Ssewanyana ne Honorable Ssegirinya. Kiringa amateeka agakola Honorable Ssegirinya ne Honorable Ssewanyana agaawuka ku mateeka agakola ku balala. Tuleese ensala za kooti endala eziraga nti nno buli kooti weba faced ne contradiction oba wabaawo okukonagana wakati wa mateeka agatambuzibwako emisango gakontana ne constitution kooti zibadde tezirwawo na kulwawo nga zigamba bamulowooza ensonga yeetaaga okutaputa constitution mugende mu constitutional court. Sitegeera fe twandisinza okwagala omusango gwaffe okwangu naye sitegeera lwaki bwe tugamba nti twagala ensonga zino zimale okusalibwa constitutional court kyokka tukomawo okuwoza lwaki ate kaakati tulaba state ewakanyanga bwewakanye naye nga kyebayambisa kiri kimu bagamba eddembe ly'abasibe wano liri wansi w'eddembe ly'abali abajja okubawako obujulizi ne bwe tutamanyi bwe bakwese ng'eddembe libasaba nti temutukweka bujulizi twagala abajulizi tubamanye n'obujulizi tubutegeere nga constitution bwegamba ba constitution egamba nti olina okuweebwa byonna byonna n'ebizibiti obujulizi bwonna abajulizi bonna ebizibiti byonna birina okuweebwa ng'omwowaabirwa osobole okulaba nti weewozaako kiri mu article 28 ya constitution. Then wajjawo amateeka gano ge bagamba nti gava bunaayira mu ICC ageyambisibwa division eno yokka yokka nga gamenyawo ennyingo eri non-derogable mu constitution y'eggwanga lino. Amateeka gali agatambulizibwako emirimu gya kooti eno gayinza gatya okumenyawo constitution. Tugamba nti ensonga eyo engeri gyekwata ku kooti eno tejja kusalira enkima tesobola kusala gwa kibira. Eno ICD teyinza kugamba nti amateeka kwetambulira makyamu nti olw'okuba enkima tesobola kusala gwa kibira gwe guveemu kuba toyinza kugamba amateeka ago nti makyamu. Tugende mu constitutional court etusalirewo oba amateeka kwotambuliza emirimu gyo nga kooti matuufu mu nsonga eno oba nedda neera ng'enkima bwetasala gwa kibira era egambye nti ffe tujja kutambulira amateeka agaffe newankubadde tubagambye nti nno makyamu bagambye nti olw'okuba tewali yali agawakanyizza kyekisinza okuba ridiculous nti olw'okuba tewali yali akomplaininze ku mateeka gano ate nakyo si kituufu omusango wa kwoyero we twaliira nga bannamateeka era amateeka twakola ki twagawakanye so tulabye nga waliwo ebirumira mu nsala ya kooti eno naye ku ngeri gye tugenda mu maaso tugenda kutuula nga bakulira n'abawaabira bataleese mu kooti olwaleero ate nakyo kimenya mateeka okulaba nti nno tusalawo engeri gye tugenda oba tugenda kuba tebagaddeewo wantu twadde tulowooza nti kijja kwanguyira kooti eno okusindika mu constitutional court ne kati balinga abatugamba nti bamwagala mugende by way of a constitutional petition so tegunnagwa mu kulaba ntuwaanira eddembe ly'abasibe bano tugenda kukola buli kimu under the sun. Abalowooza ntukoze bingi nnyo trade application eno objection eno tukoze bingi tutandika butandisi bwe kiba kikwata ku ddembe lyabwe ery'okuba nti nno bannabyabufuzi emisango gyabwe gikwatibwa differently tugenda kukola buli kimu ekisoboka mu mateeka okulaba nti tulwanira eddembe lyabwe.
Thank you so much, Council. Council Malende. Council Malende. Council Malende. Kanti mesaje ogwekirira aba ngenda kukikwatira ku mwana we. Jangu wano. Wano. Kasetulemu board. Okay.
As a lawyer who has been following the proceedings, and you were here last time, what do you have to say?
Omulamuzi asomye ensalawo gye yawa oludda oluwaabi ng'alukkiriza okuleeta obujulizi obukweke. So ffe tutulabye ku mulamuzi ng'asala ensonga ze twamuleetera mu maaso ze twayagala atunuulire tulabye nga addamu kusoma bye yasalawo edda emabega kye tulaba nti kibadde kikyamu era kye tuwakanya. Ekyokubiri, omulamuzi atudde mu musango guno oba mu nsala eno n'alaga nti ye mulamuzi agutuddemu ate era n'alaga nti yatudde nga constitutional court okusalawo amateeka gaabwe ganyigiriza oba nedda. Ate mu kiseera kye kimu n'agamba ye mu kulaba kwe amateeka tegalina buzibu ennaku 15 zijja kumala ababaka okulaba nti abajulizi abo obujulizi bwabwe butunulwako mu nnaku 15. Wabula ffe kye twaleese mu maaso ge nti bwe tuba nga tufunira principle ya fair hearing ekkiriza abantu abavunaanibwa okuba nti baweebwa ebiseera ebimala n'ebintu byonna ebigenda okulirayingibwako okubaleetako obujulizi bonga olwabi lwa side ya gavumenti emaze omwaka mulamba nga just ekuŋŋaanya bujulizi netuuka n'okulaba nti alinayo 17 beerina okukweka feegamba nti ennaku 15 bwe zinaabanga zituuse ng'okwoza kunaatera olwo ffe tutandika okufigitinga na buli kimu ate nga n'amannya gakwekeddwa ag'abajulizi so ffe tugamba nti ensonga ezo twaba nga zikontana n'okulwanira eddembe ly'obuntu naye nze ekisinga okunnuma nti zino ensala ezikusalibwawo abantu bayinza okulooza nti za Ssegirinya na Alan naye nkya naawe bw'onojja mu kkooti ng'olina omusango ogufaanagana ogwo bagenda kukwata ensala ng'eno bagikozese babeere ng'eddembe lyo bagamba nti tolirina kweyongera mu constitutional court.
What is your take on the court decision?
We disagree with the decision because, respectively, because we know that we raised questions for constitutional reference, but we have had the land judge repeating or making a repeat of her decision in the witness protection application, which we think is not something that is really proper. So we believe that she has not addressed the questions that we raised, but she has raised her own issues, which has made it possible to actually address the questions that we really filed. But also, we are seeing a problem with this decision because it is not only going to affect Ssegirinya and Alan, but these are precedents that are set by courts of judicature that any other ordinary Ugandan, when he or she walks into this court the next day, should be denied the constitutional reference basing on such a decision. So as lawyers, we are going to sit and see how best we are going to handle, because we feel that our clients are not going to get fair justice with the non-disclosure. It has taken state a year to investigate this case and to even identify 17 witnesses that require protection. But they expect the accused persons to get only 15 days to the trial to do all the information, to do all the verification, and then do the represent. We respectively disagree, and we believe that it's unfair to our clients.
Thank you.
Thank you. Thank you so much.
Yes.
Yes, kakati tulano ku ICD court nga bulijjo naye ensala evudde mu court twali tusabye nti emisango gino gisindikibwa ku constitutional court oba ku court etaputa amateeka olw'ensonga nti tukwekeddwa abajulizi 17 ate ng'omuwabi wa gavumenti agamba nti bane 17 be bakulu ennyo era be balina obujulizi obulumika ababaka nti baatematema abantu ebijambi e Masaka. So twade tusuubira nti okukweka abajulizi abo engeri ssemateeka gyakigaana kuba ssemateeka agamba nti buli muntu yenna anaaleetebwako omusango ajja kubuulirwa ng'abajulizi atunule mu statements zaabwe abagenda omuwaako obujulizi aleete bamuwe n'ebizibiti byonna bye bagenda okutundako asobole okubitunulamu yeeteeketeeke. Ekigendererwa kyali nti ekisooka okusobola okutunuulira okugamba nti mubana abajulizi abaze ono ye mumanyi oba simumanyi. Ayinza okumanga omuntu bamuteeseteese buteesiteesi ajja kuweeka obujulizi naye nga tomulabangako. So kikuwa obudde okwetegereza abantu abo n'okubanoonyerezaako ebibakwatako n'okulaba nti bano bajingejinge oba kristono omuntu mumanyi. Ekyokubiri kikuyamba okutegeka obujulizi bwo n'oba nga toli ambushed oba nga togwiriddwa kugwirwa nesobola okuba nga amazima n'obwenkanya kukola ki bivaayo. Naye okugamba nti n'abajulizi bakwekebwe nti kooti egambye nti ebalansinze bulungi abajulizi baba ne 17 bakwekebwe mujasi tujja bawayo ennaku 15 ng'omusango gunaatera okutandika tulyoke tukole ki mulyoke mukole ki mutegeera obujulizi bwabwe ate nga nabo temugenda batunulira ku maaso temugenda kumanya mannya gaabwe temugenda kumanya gye babeera. Kakati mu misango egifaanana nga gino waliwo obuzibu bw'amaanyi. Oyawula otya omujulizi asasuddwa oba ateekeddwako ng'omucuba akyalumiriza Ssegirinya oba Alani oba omuntu omulala yenna olw'ebigendererwa ebirala naddala mu kiseera kino nga bagamba nti ebintu byekuusa kukuba nti byalimu ebyobufuzi ebyokubanja entebe y'omukulembeze amba nti ekyakwasisa bano nti baali baagala okutta abantu Robert Kyagulanyi Ssentamu pulezidenti waffe asobole okutwala entebe ye kubanga bannayuganda baali bamulonzi kakati emisango giba nga giriko ekijja ku ntebe ennene ng'ate tukimanyi bulungi nti abatudde mu ntebe ezisembayo balina obuyinza bungi be balonda abalamuzi be balonda ba siteeti be balonda ba DPP be balonda ki tosobola kukwata musango gufaananga guno n'ogubalanga omusango ogwa bulijjo nti okweka abajulizi otherwise olisikinga abantu okulowooza nti nno wayeeyeza abajulizi 17 n'obateeka mu kasenge n'obawandiikira amannya n'obategeeza be bagenda okwogera bo ne bakusaba ekintu ekyo ndife tujja kukola ky'oyagala kubanga abantu bayinza okutukuba olw'okuwaayiriza n'ekirala ffe tugenda kubuukawo n'akaffe naye ffe tetwagala abantu batutegere nti ffe tujja kwogera ky'oyagala kakati mwagala muti abantu bategeere beesige prosesi yammwe gyegenda kuba y'amazima na bwenkanya ng'abajulizi mubakwese 17 ku musango ogulimu ebyobufuzi ogulimu ebyobufuzi ogulimu ababaka so waliwo challenge y'amaanyi nnyo era ffe nga bannamateeka bakiikirira Ssegirinya ne Alani ne bano abalala oba abantu abanyigirizibwa ekigenderwa kyaffe tekiba kyakuba nti tuba tutunuulidde bano bokka ababaka naye tukimanyi nti buli nsala esalibwawo mu kkooti nga zino eba egenda kubeera ng'enyigiriza buli munnayuganda omulala yenna kuba eno ensala ng'ekoleddwa olunaku olwaleero egamba nti rules za kkooti zino zina kubanga zezijja okukola yadde constitutional court weeri zezijja okukola kubanga ICC zetambulirako era basayininga Rome statute kakati enkyo omuntu omulala bw'anajja ng'alina okwemulugunya nti bamukozesa abajulizi 5 abajulizi 10 abajulizi mmeka omuntu ajja kuba takyalina weyekubira nduulu kubanga waliwo decision ya kkooti egamba nti abajulizi baddembe okukwekebwa kakati ekyo kirina obulabe bw'amaanyi era bwe mba nkujjukizaako kati nti bw'oba otunuulidde emabega waliwo abajulizi abaawanika abamu co-accused abaawanika ne bagamba nti baatukuba emiggo ne batugamba nti tetukola ki tulumiriza ababaka kakati ng'olina rekodi eyo ng'oli obadde ofollowinga omusango guno ne bagamba nti ate waliyo 17 omukweke ogutannalabibwako ensi eneekakasa etya nti abajulizi be mugenza okuleeta mu kkooti bamazima na bwenkanya si bakookinge temwatendese batendeke balumiriza ababaka ekyo kyekizibu Uganda ne Masaka eri interested okumanya abatemu abatuufu Uganda tali interested mu kubaako abasibibwa okusobola okugamba abantu nti twasibayo ku bano naye buli muntu ali interested okulaba nti ebijambiya biggwawo era n'okumanya abatemu abatuufu so ffenna twandibadde tuyambagana ne tumanya abatemu abatuufu so n'olwekyo kyandibadde kirungi nti witness protection yawo nyamba omugjewo get mukolawo disrupting avoid okitegeera so kyengezaako okugamba kyekyo kyennyini munnayuganda awuliza era kyetugamba ne bannaffe bano abakulembeze ffena tuli mu misango gino nti kubanga just lwakubanga Ssegirinya ekoba Alani naye tukimanyi nti ensonga ekwata ku mazima n'obwenkanya egenda ddala ku root eya justice mu country ate n'enkya n'omuntu akoze ensala eyo oba oyo amulonze oba omwana we oba muzzukulu ensala eyo esobola okukakinga up n'omuntu oyo nebeera ng'ekozesebwa naye so bwe tuba tukola ensala zino abalamuzi tubawa ekitiibwa kubanga asala nga ye bw'aba alabye naye ekintu kyonna ekiriko kumulugunya ku constitution tulaba nti ffe tubadde actually tuprotectinga justice system yonna kubanga tekimakinga sense eri omuntu nga nti wali abajulizi 17 naye tebaagala kubamanya tebaagala yadde abatunulako tebagenda kukozesa amannya gaabwe gaddala teri agenda batunulako naye ate balina obujulizi obugenda okuwanisa kalabba ekyo kyabulabe ennyo mu nsi Uganda emanyiddwa nti erimu baabaavu mu nsi Uganda emanyiddwa nti erimu corruption mu nsi Uganda emanyiddwa nti erimu okusosola abantu okusinziira ku party lines ebyobufuzi byabwe mu nsi Uganda eriko tribal sentiments nti abantu beesosola mu mawanga decision eyo ekola mu systems ezirina democracy ezitegereka nti eyo democracy balishuwa nti bwogenda mu kkooti kiba kyekyo teri bufere esystem ziri independent naye mu Uganda nga tukyalina challenges tulwana n'okukyusa ku constitution obuyinza bw'abantu abamu abalonda abantu tubukyuse nga tekinnakolebwa eyo decision eba egenda kufuna challenges mu democratic oba mu society ekyalwana ne democracy. So n'olwekyo era nange nga munnamateeka nyongerako eddoboozi lyange okugamba nti omulamuzi tumuwa ekitiibwa, kooti tuziwa ekitiibwa, naye twagala kooti ate n'abantu aba bulijjo baddemu essuubi mu makooti nga tusala n'omuntu owa bulijjo atagenda mu lokalasi kyalaba nti nno kigenda kuyamba enkya okuleetako obujulizi. Senga bagamba nti wasiza omusango ne bagamba nti waliwo abajulizi abakulumiza nti wabbye, naye abajulizi abo tebaagala balaba bakukweka. Okiwulira otya? Tojja kubategeera paka ng'ebuze wiiki emu oba ng'ebuze ennaku 3, naye nga bo babategekedde okumala omwaka gumu n'ekitundu bajje bakuweeko obujulizi. Okitegeera? So muno mwe mulina omuntu eyareetebwa mu kkooti nga tamanyi bwe yatuukamu. Juzi omulamuzi yagamba nti simu sijja kumuta, naye ate sijja muzzaayo Masaka asigale mu prison. Owookubiri ettu kakati ettu muwonge Jude era leero taleeteddwa. Kakati nga tuli mu musango gulimu zigizaga afaanana bw'atyo, ensala eyo ebeereko ebibuuzo bingi mu matu ga bannayuganda era abantu bo basuubira nti ensala zino bwe zinaagenda bwe zityo mu maaso, system ya rule of law oba ey'enkola y'amateeka egenda kuba nga eri abused, ate n'ekirala egenda kubeera nga ereeta obutali bwenkanya eri abalamuzi, ate n'ekirala kigenda kupromotinga embeera eyo naye nga si ya buvunaanyizibwa yadde n'akatono. Anti buli muntu agenda kutandika okugamba nti engeri gy'obeera omujulizi olina kwekweka. Buli muntu agenda kunoonya system kagamba kanoonye we neekwekera, kubanga kasita nsobola okwekweka akozesa decision y'omulamuzi agambe waliwo decision eyakkiriza abantu okwekweka. So tugamba nti
webale kulaba Kk Tv Uganda. Get informed and updated on issues around you and the globe as well. Kk Tv. Thank you for subscribing to Kk TV. Webale kulaba Kk TV Uganda. The inspiration and the best broadcasting around town. Kk TV. The global experience. The might